Hello friends. Today we're going to discuss about e-health. I'm Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about e-health. What is the definition of e-health? What are the challenges we are going to face when we are dealing with e-health? And also, ethical and legal issues will be discussed in this video. Let's understand what is e-health. Invariably, e-health and also digital health are used interchangeably across the world. But what is the definition? E-health means the use of digital technologies, information, and communication system in the healthcare industry to improve the delivery of medical services and facilitate better patient care. Here, e-health encompasses a wide range of applications and services that leverage electronic means to enhance healthcare processes, prompt preventing medical illnesses, enable remote monitoring, and empower the patient to take a more active role in their managing their health by themselves. That means e-health plays a crucial role in the modern world. As per World Health Organization, e-health is defined as use of information and communication technology for the purpose of health. It includes telemedicine, electronic health record, mobile health, e-pharmacy, health wearables such as smart watches, health information exchange, health applications, usually called as digital health tools, artificial intelligence for the purpose of health, storing the health information, and so forth. But however, one need to differentiate between e-health and digital health. Grossly, both are same. They are interchangeably used. But if you would like to know what is digital health, it refers to the use of digital technology, information and communication system in the context of healthcare and medicine. Here, the word in the context. Invariably, digital health is an umbrella term which also includes e-health. That means digital health includes e-health. Invariably, one need to understand digital health also includes such as personalized medicine, health data analytics, big data, machine learning with regard to health, electronic medical devices, software associated with the medical devices, digital phenotypes, and so forth. Here, we will be more dealing with digital phenotypes and various others along with health. That means the best word to use nowadays is digital health rather than e-health. Now let's understand what are the issues surrounding e-health and digital health. First and the foremost, you need to know health industry is highly regulated. Suppose you want to start a hospital or a clinic or even a medical college. They are governed by minimum 60 different legislation, regulations, rules, and notification. On the other hand, information technology, applications, AI, they are all minimally regulated. That means the regulations with regard to these newer technologies, there are few regulations only. At this point of time, we need to marry both health and digital technology. One is highly regulated, another one is poorly regulated. Suppose if you have developed digital health applications or medical devices and you have written artificial intelligence algorithms, if something goes wrong because artificial intelligence is writing its own algorithms and during the healthcare delivery services, if the patient is injured, whether this software will be held responsible? Can we hold this non living subject for compensation? It's simply impossible. That means someone needs to be answerable if there is something goes wrong with the patient. Hence, the concept of human in the loop has been brought into picture. That means when you plan for artificial intelligence, when you start coding, when you start developing, when you start deploying in such a scenario, a healthcare professional need to be involved, and they are the human in the loop, which or who are responsible for the patient care, and if something goes wrong, they will be held responsible. The next question comes is if there is any copyright violation, especially with regard to artificial intelligence, they are going to use a big data, the data from various sources, and develop various information, various photographs, maybe products. Now the issue is copyright. They have copied it from multiple sources. Who will be given the copyright? And also, whatever the benefits they are going to yield. That means AI is already violating the copyrights. The next important is biases. Invariably, the artificial intelligence is data driven. If the data is good, the response will be good. If the data is biased, or else the data is skewed, the response also will be skewed. Now, if something goes wrong, who will be held responsible? Again, this issue need to be asked and also answered. Further, information and technology is growing very fast. It is unregulated. Every month, there is a new growth and new heights are achieved in the area of information and communication technology. With regard to health research, they are very slow. That means if you want to introduce information and communication technology in health, by the time you do trial and the results are out and adapted in the industry, the information technology would have taken leaps and bounds, and they are maybe around 10 years ahead. That means there is a huge lag period with regard to health research and even implementing information and technology in the area of health. Technology divide. There are certain areas across the world, they are not accessible for many people who are in the rural area and remote area. This will cause digital divide. This digital divide will cause discrimination for those people who require the health care and they need to be taken care. If there is no local data input is given to this digital driven healthcare, then this will cause serious impact. For example, if you are done using artificial intelligence, certain studies in Western country, can those softwares or artificially intelligence driven tool can we be implementing in countries like India or Asian countries? Is it possible? Because the data is from somewhere else. And then the response will be not be appropriate in those situations where it has to be implemented. Hence, the local data input is very, very essential. Although this information technology is amazing, serving many people and saving lives. Suppose if this falls into the wrong hand, what will happen? Let me put it in a simple context. This AI driven tools or else artificial intelligent tools are like a nuclear weapons. This can be used to harness energy at the same time destroy the human mankind. Similarly, if this IT technology and artificial intelligence falls in the wrong hand, what will happen is a big question we need to answer now. Further, there are many digital technology, health applications, mobile applications are released into the market every day in thousands. Unfortunately, they are not regulated. They are not tested on the patients. And these applications, developed by various engineers, young engineers, without thinking about the ethics, rules, and regulations, and how it has to be operated with patients, they are least bothered. And if these unregulated applications may cause serious injury to various patients and also the family members. Similarly, various telemedicine applications, portals, they are not regulated. They are becoming a commercial entity, exploiting patients and also the healthcare provider. These industry needs to be regulated at the earliest. Finally, the biggest challenge is data security. Here, on one end of the spectrum, there is a doctor, on the other end, there is a patient. And whenever you are using digital technology, there will be devices, medical devices. There will be these medical devices will collect data and send it to the doctor through modem or a router. There is an internet service provider. There is a cloud where the data is stored. There may be an insurance company which is paying for the health services, medical devices, electronic health records. And these health records, either the doctor himself is writing the information or else a third party medical transcriptor is writing the information. And if the prescription is sent to pharma industry, they are accessing these health records. And invariably, if the patient is paying himself, the bank comes to know where he has consulted, how much money he has paid. Look at the people involved in between the doctor and the patient. That means this doctor and the patient relationship, there are many people are involved. That means we need to regulate each one of them. Otherwise, if there is a data breach occurs, whether the doctor is responsible or else the patient problems will be addressed or not. Hence, in this regard, Americans have come up with a solid regulation and rules, the law called as HIPAA, that is Health Information Portability Act of 1997, plays a crucial role. It regulates the data creators, that is doctors, nurses, and healthcare providers, transmitters, that is devices, routers, internet services, and the cloud, business associates, such as insurance, medical devices, banks, subcontractors, computer management, those people who take care of these computers, all are regulated. If the data breach occurs by any of these players or the stakeholders, they will be held responsible. At this point of time in India, we do not have a comprehensive regulations or rules to regulate this market. Hence, online security and physical security is the biggest challenge with regard to e-health, my dear friends. Now let's understand what are those legislations which are available in India. Let's trace the law with regard to e-health. The most important legislation is Information Technology Act of 2000, that is IT Act. This act came into force in 2000. This came into picture because there was a need to provide a legal recognition to the transaction carried out by means of electronic data, by interchanging or other means of electronic communications, commonly called as electronic commerce, which involves the use of alternative methods of paper-based or electronic-based communication and storage information. And these storage, electronic signatures required legal sanctity. Hence, the IT Act came into picture. This provides validation for e-contracts, my dear friends. And there was an amendment even for the Indians Evidence Act of 1872, giving complete power to the IT Act where e-contracts were valid. Hence, if the patient during the transaction, along with the healthcare provider, if he accepts the terms, privacy policies, agreements placed on the electronic platform, and if he agrees by clicking, by telling that I agreed to this, then it is deemed the patient has given consent for the procedure, for the storing the information, transmitting the information, or else using it for various other purposes. That means IT Acts gives the power under the IT regulations so that the patient consent can be obtained through electronic format. Further, IT Act Section 43 also says that the corporate bodies who are possessing or dealing with or handling any sensitive personal data or information in a computer resources owned, controlled, operated by it would be liable to pay damages or compensation to the affected person if they are negligent in implementing and maintaining reasonable security practices and procedures to protect sensitive personal data or information. What does it mean? Section 43A is very clear. Any entity who are involved in collecting health data, transmitting, sharing, and also storing those data, retrieving this data, doing analysis. Any of these people who are involved in this scenario, and they need to provide reasonable degree of security. And if they do not provide any kind of any reasonable security, and if there is a data privacy breach, they will be held responsible by paying compensation to the patient. Under IT Act of 2000, there are various rules have been notified. You need to know two important rules. The first one is data protection rules, or also called as SPDIR rules. The second one is intermediary rules. I'll be discussing both of them. The first one is data protection rules, also called as Information Technology Rules 2011 or SPDIR rules. Basically, it talks about reasonable security practices and procedures and sensitive personal data or information. In this rules, SPDIR Rule 2011, Rule number 3 mandates a written consent invariably under IT Act. By clicking, the person will give consent for sharing his data. That is, during collection of data, storing the data, and also by chance if you are sharing, the patient consent is mandatory. What are those sensitive personal data under these rules? As per this rule, the sensitive data are password, financial information, physical, physiological and mental health conditions data, sexual harassment and orientation related information, medical records and history, biometric information, and any other details relating to the above clauses as to provide it to the body of corporates for providing services. These are considered as sensitive information and they are confidential. Now let's discuss about the important case. This is Avinash Bajaj versus State. Here, the role of intermediaries came into picture. Let's discuss about this. In 2007, two young kids from Delhi, they were having romantic relationship. During that time, the young boy started filming his girlfriend. And this piece of video went into the hand of Mr. Raviraj, who was the fourth year student of IIT Kharagpur. And he sold this video clip on eBay Commerce. At the time, it is called as Bazi.com. Invariably, this happened in 2008, my dear friends. And this video clip was sold to many people on Bazi.com. By the time, it became a news headline. Hence, since there were children who were involved in this, maybe called as pornographic material, and it was sold online, and it was illegal as per the law. But however, this became a big issue, and the police lodged a complaint against Mr. Raviraj and also Bazi.com CEOs. One of them was Avinash Bajaj from New Delhi. Invariably, Avinash Bajaj said that we are a platform. We are providing platform to the sellers and buyers. Invariably, in this scenario, here, this young boy Raviraj placed an ad telling that books and videos are available for sale on Bazi.com. And the Bazi.com here, even in their website, it was not hosted. After paying the money, the video was emailed to the clients. Hence, the Bazi.com said we are not responsible and we did not know this person is doing like this. And this went to the Delhi High Court. During the charge sheet, all these three people, that is Raviraj, the Bazi.com CEOs, were charged under both IPC section and also ITC Act. Under IPC section 292 and 294, sale of obscene materials, books, acts, songs, videos under the Indian Penal Code. Under the IT Act of Section 67, it clearly discussed about punishment of publishing or transmitting obscene material in electronic form. Section 85 talks about offences done by the company. In this, Delhi High Court was very categorical and clearly said that the Bazi.com cannot be held responsible under IPC section, but they are punishable under the IT Act of Section 67 and Section 85, and they also clearly made an order where the central government had to come up with intermediary rules, regulations, or guidelines. In this regard, the government of India came up with intermediary guidelines rules 2011. According to this, intermediary are also called as aggregators. What do you mean by aggregator or an intermediary? Which clearly says that similar to Uber or Ola, these are aggregators or a software companies which onboard on one hand the service providers such as drivers who bring their cars. On the other hand, the customer who wants to travel will come to this platform, book the car, and they use the services. Here, the software company says, we don't own any car or drivers. They are enrolled here through an application. So, we are not responsible. That's the way these intermediary or aggregators used to say. Now, let's understand as per the rules, what does it mean? Here, these aggregators or intermediaries were brought under this rule and they place certain obligation for the intermediaries which included inter alia publication of privacy, policy, user agreement of its website, application, prohibition of posting harmful content, grievance redressal cells, developing systematic and organizational measures for data security were discussed under these rules. Let's define intermediaries under this. Intermediaries under this rule means with respect to any particular electronic record, means any person who on behalf of another person receives, stores, or transmits the records or provide any services with respect to the record and includes telecom service provider, network service provider, internet service provider, web hosting provider, search engines, online payment sites, online auction sites, online marketplaces, and other cyber cafes. That means these are those entities who are intermediaries, aggregators. They cannot wash their hand. They have an obligations under this rules, my dear friends. They also clearly mentioned under this intermediary guidelines rules 2011, they said they need to have a grievance cell officer who will receive any complaints and acknowledge within 24 hours and also resolve the complaint within 15 days after receiving the complaint. And these aggregators and intermediaries also has been casted with an obligation to remove or disable the content which exposes the private area of any person or shows nudity or sexual act or conduct, including artificial morphed images within 24 hours from the receipt of a complaint, my dear friends. And in a landmark judgment, Shreya Singhal versus Union of India 2013, which discussed about the right to freedom of speech and expression. Under the IT Act, Section 64A was squashed, telling that the right to freedom of speech and expression prevails. But however, these two important rules, intermediary guideline rules or aggregator rules and data protection rules 2011, both were upheld by the Supreme Court. In the name of right to freedom of speech and expression, you cannot violate somebody else's privacy. Hence, these rules were upheld and Section 64A was squashed, my dear friends. Now, another important law which comes into picture under the digital health, that is Drugs and Cosmetic Act of 1940 and Drugs and Cosmetic Act Rules 1945. This legislation, which is very old, which regulates the manufacture, sale, import, and distribution of drugs and pharmaceutical products. This DNC Act and DNC rule came into force very long back, and they clearly mandate license to manufacture, store, transmit, or sell the medicines. Drugs and Cosmetic Act rules clearly lay down which drugs can be sold on production of prescription issued by a registered medical practitioner, which implies a distinction between prescription and non-prescription drugs. And this act also tries to regulate e-pharmacy, but the regulation is very, very thin and also not comprehensive. Hence, there is a legislation by name Drugs and Medical Device and Cosmetic Bill 2023, which is pending in Lok Sabha. That means that needs to be tabled and discussed with regard to e-pharmacy. Here, this Drugs and Medical Device and Cosmetic Bill 2 2023 replaces the existing 80-year-old Drugs and Cosmetic Act of 1940. This law is an updated version, and they talks about regulatory norms for pharmaceutical sector. And this is not only for drugs and pharmaceutical, it talks about medical devices and also for cosmetics. This bill proposes a new definition for clinical trials, over-the-counter drugs, manufacturers, medical devices, new drugs, bioavailability studies, investigational new drug, clinical drug trials, imported spurious drugs, medical devices, and also aim to regulate e-pharmacies, my dear friends. Although this law is yet to be tabled. Now, there is another important legislation, Drugs and Magic Remedies Act of 1954. As per this Drugs and Magic Remedies Act of 1954 and also the rule, it clearly says that nobody can give advertisement and give a false promises, and spurious advertisement are banned. Let's understand what does it says. Here, as per the Drugs and Magic Remedy Act enforced in India, the main objective is to regulate the advertisement regarding the drugs. Hence, whoever is running e-health or else digital health need to know about this legislation. These e-health service providers, specifically online pharmacies, must take care that they provide an accurate and genuine information and description about the medicine or drugs which are listed on their platform. If they do anything wrong or give false information, false hopes, this Drugs and Magic Remedies Act will come into play. Similarly, there is one important legislation called as Clinical Establishment Act of 2010. According to this legislation, it defines what is clinical establishment, and these clinical establishment needs to register with the respective government. Either it may be central government with regard to union territory and state government with regard to the clinical establishment established in certain states. According to this Clinical Establishment Act, a clinical establishment means a hospital, maternity home, nursing home, dispensary, clinic, sanatorium, or any institution by whatever name it is called that offers services. That means even e-health, digital health come under this Clinical Establishment Act, my dear friends. And they facilitate requiring diagnosis, treatment, or care for illness, injury, deformity, abnormality, or pregnancy in any recognized system of medicine established and administered or maintained by any person, body, of person with incorporated or not, shall registered under this Clinical Establishment Act. That means any platforms such as telemedicine platforms or else any applications which says we are curing certain illness or providing services certain illness, they need to register under the Clinical Establishment Act, my dear friends. These are these legislations which a e-health platform or digital health platform need to be registered and follow those rules. In simple word, let me summarize. Drugs and Cosmetic Act, Information Technology Act, Clinical Establishment Act, and also Data Protection Rules of 2011, Intermediary Guidelines 2011, Medical Device Rules, and DNA technology. And another important legislation which is pending in the Parliament is Data Protection, Personal Data Protection Act, PDP bill, is still in the Parliament yet to be passed. Let's discuss about data privacy. Although we do not have any data privacy law, how they are governed and managed in India. One of the important landmark legislation with regard to data privacy is Justice K.S. Puttaswamy versus Union of India, a landmark judgment given by Apex Court in 2017. This judgment was given by 9 judges of the Constitution Bench. Here, Justice K.S. Puttaswamy, who is a retired judge from High Court of Karnataka, questioned the validity of Aadhaar card, storing of biometric data, and sharing this information with various agencies without the consent of people. And also raised a question whether this biometric data means includes under the right to privacy, and also challenged whether the right to privacy is a fundamental right or not. Here, in this landmark judgment, my dear friends, the 9 judge bench unanimously clearly said that right to privacy is protected and is an intrinsic part of the right to life and liberty, that is Article 21, and also said that right to privacy is a fundamental right and these biometric data should be protected and without the consent of the individuals cannot be shared with anybody else. And if they need to be shared, the Supreme Court has given clear-cut guidelines how to do it, along with the legislation and with the written consent, and the risk versus benefit should be waived. Then only the data can be shared and only the relevant data can be shared. And my dear friends, from this judgment, right to privacy is a fundamental right under the Constitution of India. However, we do not have a comprehensive legislation. Hence, Ministry of Health and Family Welfare, New Delhi, came up with e-health initiative. Under the Digital India initiative, they started e-governance. That is, e-healthcare was started. Under this e-healthcare, a e-health division was formed under the Ministry of Health and Family Welfare, which discussed as a policy document with terms of vision to deliver healthcare services in terms of access, quality, affordability, lowering of disease burden, and efficient monitoring of health of the citizens by using digital technology. Under this health initiative of Digital India, Ministry of Health and Family Welfare proposed National Health Authority, that is called as NEA, in 2015 as a promotional, regulatory, and standard setting organization in health sector was proposed by Government of India. At the same time, you need to understand there was a National Health Policy 2017 was released. This is the National Health Policy, my dear friends. This was released in 2017. As per the National Health Policy, it envisages the goal of attainment of the highest level of health and well-being for all the ages through increasing access, improving quality, and lowering the cost of healthcare delivery. The key principle of this National Health Policy includes universality, citizen-centric, quality of healthcare, accountability for performance are the key important point. The policies also lays a significant emphasis on leveraging digital technology for enhancing the efficiency and effectiveness of delivery of healthcare services to the remote area, my dear friends. Hence, with this National Health Policy as a background and Digital India initiative, government launched two important documents. One is National Digital Health Blueprint, which is 2019, and National Digital Health Mission, in 2020, my dear friends. These are two important policies and documents. This is under Digital India, my dear friends, a nationwide campaign to create an open digital ecosystem that aims to improve the efficiency, effectiveness, and transparencies in healthcare services. Now let's discuss about the first one, National Digital Health Blueprint 2019. This is how the document looks. This blueprint is not just an architectural document. This blueprint has a specific details of the building blocks required to fulfill National Health Policy 2017, and also talks about institutional mechanisms and an action plan to realizing the digital health in a comprehensive and holistic manner, my dear friends. And also, this National Digital Health Blueprint has a key features which is federated architecture and a set of five important layered system of building blocks. Let's look into this five building blocks. First and the foremost is unique health identifier, also called as ABA card, and registry of all the patients. The first one, once the data is taken, the privacy, consent of managing the data, and electronic health record becomes the second. Third one is the standards which are need to be developed for EHR and national portability of these EHR becomes the third. Fourth one is analyzing this data, that is huge amount of data for the purpose of public health policy. Finally, providers and health facility through multiple access such as call centers, digital health, telemedicine, and my health app, various to be implemented under this digital health blueprint, my dear friends. These are the five architecture you can see. On one hand, we have technology. On the other hand, we have health domain. And from the National Digital Health Mission, vision, principles, building blocks, standards and regulations, applications, services, and institutional structures play a crucial role. Let's discuss about National Digital Health Mission 2020. This is an important document which was released after the blueprint. This National Digital Health Mission was released by Ministry of Health and Family Welfare in collaboration with Ministry of Electronic and Information Technology and National Health Authority. This is a strategic document, my dear friends. This document has a vision to create a national digital health ecosystem that supports universal health coverage in an efficient, accessible, inclusive, affordable, and timely and safe manner that provides a wide range of data, information, infrastructure services, duly leveraging the open, interoperable, standards based digital systems, and ensures security, confidentiality, and privacy of health related personal informations. And this is the governance structure and framework. At the top, the mission steering group chaired by Honorable Minister of Ministry of Health and Family Welfare. There is an empowered committee below that, which is chaired by Secretary of Health, and there is a legal and regulatory framework which will be both collaborative. In this framework, both Ministry of Health and Family Welfare and Ministry of Electronic and Information Technology. And this also will be assisted by National Authority, Health Authority, which is the implementation body of National Digital Health Mission, my dear friends. These are the principle of National Digital Health Mission, both the domain principle and technology principle. At the center, health and wellness centers are there, and in the heart of the technology, it is the architecture. Under the principal domain of health, it is education, empowering of the patient, universal and inclusiveness of the patient, security and privacy and design, performance and accountability of health services, national portability of this data, think big, start small, and scale fast is the principle which has been considered under the health domain. Under the technology domain of architecture, building blocks, open API, leverage of legacy, minimalistic design, single source of truth, and interoperable are the important principles under the National Digital Health Mission? What are the other e-health initiatives by the Government of India? As per the National Digital Health Mission, unique health ID, which is ABA card, which is linked to Aadhaar card, is a very important document which will place an important role in recording the data, transmission of the data, and also accessibility and who can edit this data will be discussed under this important policy. However, we need a legislation, my dear friends. At the same time, there was an important Ayushman Bharat Pradhan Mantri Jan Arogya Yojana, which talks about insurance. And during the insurance, these unique health IDs are created, my dear friends. Now, let's discuss about what are the legislation which are pending in the parliament or regulations which are pending in the parliament. First and the foremost is Data Privacy Bill. The first bill was called as DISHA, Digital Information Security in Healthcare Act, and this got lapsed and it was modified into Personal Data Protection Bill, my dear friends, called as PDP Bill. And this was placed in 2022, and because of the human rights activist resistance, which was withdrawn. Hence, it has been modified and yet to be tabled again in the in the parliament, my dear friends. What are the silent features of this data privacy bill? Here, the users, that is the patients, will control their data, that is health record. End users must explicitly explain about the safeguards and also need to take consent before taking the data. That means health record needs to be taken only with the consent of the patient. Biometric data needs to have additional security features. Impact assessment of the deploying of any AI also comes under the data protection bill. And also, the people who are holding this data need to anonymize the data, prevent the re-identification of the data sets, and also prevent the leakage of the data. And if it is any unethical act is done with regard to data, sharing the data, mining the data, analyzing the data, need to be reported. Another important regulatory approval is required, that is called as BioRap. That is Biological Research Regulatory Approval Portal, my dear friends. This comes under the Department of Biotechnology. Suppose if there is any health applications which is manufactured either in India or else abroad, or else in collaboration with various country, and you are going to use this application or a portal for doing research or deploying in the country for the purpose of treatment, they need to take the permission from the BioRap. That is very important. I have mentioned the link, that is biorap.gov.in. If you require more information, please visit this website. Along with various rules, regulation, and laws, any person who is involved in health research involving human participants and digital technology need to follow Indian Council Medical Research Ethical Guidelines. There are two important guidelines. I'll be discussing them. The first one is National Ethical Guidelines for Biomedical and Health Research involving human participants, which was released in 2017 by Indian Council of Medical Research. That means any person who is doing research on human participants by using digital technology on health research need to follow this important ethical guideline. This was not just a guideline. This is a living guideline which evolved from 1980, modified in 2000 and 2006, and now 2017, my dear friends. This is an important guideline which has 12 sections with regard to involving human participants in health research, my dear friends. And if you are a researcher doing various research on human participants, please follow this ICMR guideline. And if you are a person who is involved in digital technology and health research, you need to follow one more important guideline, that is ICMR, Artificial Intelligence Research and Healthcare Guideline 2023. This is an important document which is ethical guidelines for application of artificial intelligence in biomedical research and healthcare, released in 2023 by Indian Council of Medical Research. This guideline has an important objective to ensure ethical conduct, address emerging ethical challenges in the field of artificial intelligence, and to provide a framework for ethical decision making in medical artificial intelligence during the development, deployment, and adoption of AI based solutions, my dear friends. To whom are these ICMR guidelines applicable? It applies to all the stakeholders involved in research with artificial intelligence, biomedical research involving human participants, and in healthcare. They are digital creators, developers, researchers, entrepreneurs, clinicians, ethics committee, hospitals, research institution, sponsors, and funding organizations with regard to healthcare research, digital technology involving human participants. What are the content of this guideline? There are 5 important sections. One is ethical principles, guiding principles for stakeholders involving in AI, ethics review process in AI, governance of artificial intelligence use, and finally, the informed consent. Why was it needed? Invariably, the health sector is very well regulated, over-regulated by various laws and legislation. But information technology and artificial intelligence are poorly regulated. Hence, we required these regulations so that marrying the both technology and healthcare becomes easy. Now let's discuss about the ethical principles involved under the artificial intelligence under ICMR guidelines. There are 4 important ethics which everybody need to follow. One is autonomy, that is respect for the person. Beneficency, doing good to the person. Non-maleficency, that is do not doing any harm. Distributive justice, that is providing the available resources in effective and to the required person. That means any person involved in healthcare, research, and also information technology need to follow these 4 important ethics guideline, which these 4 important ethics further evolved into 12 important general principles which are highlighted in this AI guideline by ICMR, my dear friends. These are those important 12 guidelines. They are validity of this data, non-discrimination and fairness when providing services, optimization and data quality, accessibility and equity of this AI technology, risk minimization and safety of this AI, collaboration, autonomy, data privacy, accountability and liability if there is anything goes wrong, trustworthiness of this data, and of course validity. As you know, artificial intelligence is data driven. Hence, data protection, data safety, how the data is taken, whether the data is biased or not, how the data algorithms are written, and how the deployment occurs, adoption occurs. In this whole process, this guideline gives a framework and how you need to operate. To conclude, my dear friends, there is an urgent need for comprehensive legislation with regard to e-health, personal data protection, safety, security is paramount. Unregulated research in the area of information technology involving human participant is very disturbing. Unfortunately, various researchers who are young, enthusiastic, without taking the ethical principles in mind, they apply this data or else digital technology on humans and patients, my dear friend, and that is unethical and illegal. Hence, we need to curb these practices. Hence, we need to have a comprehensive legislation. Health applications, telemedicine applications, portals need to be regulated. Unfortunately, various telemedicine applications are in the market promising various things and delivering nothing. Hence, my dear friend, we need to regulate these applications. And AI related health research need to follow ICMR Ethics Guideline 2017 and also 2023 AI research guidelines need to be formed and need to be followed. Human is in the loop needs to be ensured in AI technology, and invariably healthcare provider is the person who is in between the patient and the technology, hence involving the healthcare providers, doctors and nurses in the planning AI related any technology, or else planning, writing the code, deploying, and also adapting. And these people are very important stakeholders and they need to be taken into confidence. And if anything goes wrong, and these are the healthcare providers who are involved, should be held responsible. And my dear friends, not only the healthcare providers, all stakeholders involving in AI will be accountable if anything goes wrong with the patient. Thank you very much for giving your valuable time discussing about e-health, laws, and ethics. Thank you very much, my dear friends. Stay safe.